Case caption State of Ohio versus Lorenzo Robinson, case number 25 CR 0000180. We were last here on September 5th, at which time, following a jury trial, the defendant was found guilty of count 1, having weapons under disability, felony of the 3rd degree in violation of Revised Code Section 2923.13A3, as well as count 3, possession of cocaine, a felony of the 5th degree in violation of Revised Code Section 2925.11. The case was then referred for a pre-sentence report and investigation and a drug and alcohol.
Boom, the judge announces that the case was referred for a pre-sentence report and investigation, including a drug and alcohol evaluation. These assessments have now been partially completed. Today, the courtroom gathers once again for the purpose of sentencing. The defendant stands before the bench, accompanied by his attorney, Mr. Corey Hinton.
Thank you. Mr. Hinton, any reason not to go forward with sentencing?
No such reason, Your Honor.
Anything you'd like to say on behalf of your client?
Yes, Your Honor. As you know, Mr. Robinson did contest the charges in this case, but nonetheless, in light of the verdicts reached by the jury, as far as sentencing is concerned, I'd ask the court to put emphasis on the fact that the conviction for possession of cocaine F5 was a residue amount of cocaine, so obviously a very small amount of cocaine as far as that charge goes. As far as the other charge goes, the weapons under disability, the court was able to hear from multiple witnesses regarding this during the trial. I'd ask the court to take what was said into consideration for mitigation, specifically the side of the story that was presented by the defense as far as how the guns were positioned in the vehicle.
I'm supposed to consider that side, not the other side?
Well, for purposes of sentencing, I am asking you to consider that although there was a conviction, it may have been a situation where the facts may not have been as serious as other cases with having a weapon under disability, where there's more of a straightforward, clear-cut demonstration of possession or access. I would also ask you to take into consideration the fact that there has been a several-year span since the last time Mr. Robinson had issues with a felony level criminal case. Mr. Robinson has been in the jail for almost 6 months. We would be asking that you place him on community control sanctions, give him credit for the jail time that he's already completed so that he can be released, and subject to other conditions of community control that the court would impose. I understand that the pre-sentence report was incomplete. I discussed that with Mr. Robinson. He did indicate that specifically in the drug and alcohol evaluation, a trigger was hit with him where questioning about his family arose, and he felt uncomfortable to some extent speaking about that, especially in the context of a drug and alcohol evaluation. So that made him not as forthcoming as he would have liked to have been, but certainly, Your Honor, I think that because the pre-sentence reports were at least completed to some extent, community control would be a viable option. If the court does not feel that community control would be appropriate and that a prison sentence was going to be ordered, we would ask for something at the lower end of the spectrum, again, for the reasons that I previously stated. Thank you, Your Honor.
Thank you. Mr. Robinson, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
I do.
Go ahead.
I just don't understand how, like, I just actually proved to y'all I didn't do nothing wrong at all, and I'm still convicted. I just don't understand that at all. Which I don't understand. I take accountability for everything I did wrong. If I did anything wrong, I wouldn't even take it this far. I wouldn't. I would have been sentenced already.
Is that the last thing you said?
I would have been sentenced already. Got it over with if I did anything wrong. I actually didn't do nothing wrong this time. And I'm cool with that. Like, I got a smile on my face. I just got my mental together. I want to say thank y'all for that because, like, everybody need a mental check sometimes. And I had a reality check in that jail. That ain't for me, bruh. That's not for me at all. I grew up. Y'all didn't want me to grow up, but it's cool. People grow up. People do grow up. Sorry, but other than that, y'all taking me from my family, and I ain't even do nothing wrong. Why? That's all I'm asking. Why? I ain't got nothing to say.
Thank you, Mr. Hinton. Anything else you want to say on behalf of your client?
Nothing further, Your Honor.
Ms. Linden for the state.
Thank you, Your Honor. Your Honor, as I indicated in chambers, the state is requesting a prison term. I'm not looking at the lower end because he has been to prison several times before. The last time I believe was 13 months. The defendant has a history back to 2007. His history is riddled with drug charges and disrespect for the law, disrespect for probation, refusal to complete things. He refused to complete this PSR and the other paperwork. This is not his first rodeo. It's not as if he doesn't know what the process is. And in terms of looking at even some of his history before, when he was asked to do some things for NeoCap, he refused to be interviewed for NeoCap back in 2021. He's had a bunch of issues with that. Here with the institutional summary even, it's riddled with him disobeying, the officers disrespecting people, punching an inmate in the face. He had that positive marijuana screen, and then I've never read a report where someone who's doing a drug and alcohol evaluation had such an issue with somebody that they had to have a corrections officer stand by because of it. And he was resistant to answer any questions. He says something to the effect of, I lied on the PSI because I never even did drugs before, which is clearly not true. He got very belligerent when there were questions asked about the family, and I know Lisa Friend tried very hard to be cool, calm, and collected with him, but he continued to be uncooperative and basically told her to stop asking dumb questions. So in terms of that and looking at the level of disrespect that he's had in his history, there's no way that he's amenable to community control. He takes no responsibility for his actions at all. And when we look at his history, there's just not a way to find him amenable to community control sanctions. If he can't even comply with simple things like completing a PSR or answering some questions, certainly community control is not appropriate. This is a report that's filled out to try and assist, at least for the court and for anybody.
Here the prosecution notes that even with opportunities for rehabilitation, the defendant refused to participate. He has already served 175 days in custody, time credited toward his sentence. The state renews its request for the original forfeiture and formally asks that a prison term be imposed.
Thank you. This court has reviewed there's no pre-sentence report that was completed. I've reviewed the information that was provided to the court by the probation department, but a complete pre-sentence report investigation was not completed because of the defendant's refusal to cooperate and provide the information that was requested of him. I don't have a completed drug and alcohol evaluation because of the defendant's refusal to cooperate and talk with the evaluator in that case. She made an effort, she brought him up, she talked to him, and he just sat there saying, I ain't answering that, it's none of your business, she needs to stop asking me these dumb questions. And as the prosecutor alluded to, I haven't seen a report like this where they need to bring a corrections officer in to sit in with her because of the defendant's attitude that he was presenting at the time of the interview. So I don't have a drug and alcohol evaluation. I've considered the facts and circumstances of the offenses. I presided over the case, heard all the facts, taken those into consideration. Taken into consideration what's been said here in court today by the defendant, his lawyer, the prosecutor. All this is considered in light of the purposes and principles of felony sentencing set forth in 2911. As for the factors in 2912, nothing stands out factually indicating it's more or less serious. This court is not required to adopt the defense's version of what happened in this case in terms of why he may have been in possession, though he completely denies it. He says he didn't do anything wrong. But I'm not required to take their version of this and then make us finding that, thinking of their version, this is less serious than normal. I heard all the evidence, and in my view, the jury came up with the correct verdict. All this has been considered, however, in light of the purposes and principles of sentencing again. Nothing makes it more serious, nothing makes it less serious. As for recidivism factors, many of these factors are present. The defendant has a lengthy history of criminal convictions as well as juvenile delinquency adjudications when he was a minor, going back, what are we at, almost 20 years, 2007, so 18 years of criminal conduct, delinquent conduct. He's been to prison on multiple occasions, I think 4 times.
No, 3.
Only 3. He's got multiple probation violations, so he hasn't complied or has failed to comply with the previously ordered sanctions of a court. Multiple probation violations, so he's been
I
given
never got a chance to be on probation, so I was last
So
time.
you've had a chance to speak. Now it's my turn. I'm looking at your record. You've been on probation before. You're telling me you haven't been on probation before.
I have not.
Well, you're lying.
I have not been to the joint 3 times.
You were on probation to Judge Collins in 2010, and there was
No,
2
I
separate
wasn't. You
probation.
sent me to prison.
On probation violations,
No.
well, you were given 1 year of probation, 90 days jail suspended, and then you were given a probation violation, and you were continued on probation. Then another probation violation, you were sent to prison. You were given probation by Judge Lucci in 2020 for the attempted failure to comply with an order of a police officer. You were violated and went to prison.
No, I went to NeoCap.
And then you
I didn't
violated
violate.
and you went to prison.
He told me because they was crushing.
NeoCap is probation. If you go to if you get NeoCap, you're on probation.
That's not my fault. They was messing up my pills when I was
Why I'm
there.
arguing with you. You were given 3 years of probation with conditions. One of the conditions was NeoCap, and you've violated your probation, and you're ultimately sent to prison. Am I reading that wrong, Kaylee?
No, you're correct.
You can look at the record. You can look at the docket.
I know what I did.
Yeah. Apparently you don't.
I do. I'm the one who went
You
to
got
prison.
a very poor institutional record when you were in jail with disciplinary incidents and infractions that you committed. There is absolutely no remorse, let alone genuine remorse, but no remorse at all, except no responsibility. Violated conditions of his bond and testing positive.
I never violated that either. I had no stipulations.
It's clear that the defendant is not amenable to community control sanctions. He can't even sit here quietly as the court is speaking. He keeps interrupting. He's been given a chance to speak, but he keeps interrupting. He won't cooperate with probation. There's not a complete PSR. I'm not even authorized to put the defendant on probation because he wouldn't cooperate with them. He wouldn't cooperate with the drug and alcohol evaluation. He has zero respect for anyone with authority. He's going to do what he wants to do regardless of what anyone says. You even said in municipal court, you're just going to keep driving. You don't care what people tell you. You're going to continue driving cars regardless of what the status of your license is. You're going to do whatever you want to do. And someone with that attitude will never be successful on probation. Prison is consistent with the purposes and principles of sentencing. Therefore, it will be the sentence of this court that on count 1, defendant serve a term in prison of 30 months. On count 3, serve a term in prison of 6 months. I'll run those concurrent for an overall prison term of 30 months in prison. He has credit for 175 days he's already served. I need to advise you upon your release from prison, you may be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can send you back to prison. As punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. I'm going to order the forfeiture of any interest the defendant has in the items set forth in the forfeiture specification in count 1 and count 3. Defendant's ordered to pay all costs incurred in this action. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Ms. Linden, is there anything else for the record at this time?
No, Your Honor, thank you.
Mr. Hinton?
Nothing further, Your Honor.